Hello, landlords. It's Ernie Garcia, landlord attorney, and today we're talking all about the unprepared landlord. Don't let that be you. Let's get started. So today we're going to watch an actual eviction trial held in a Texas court, and the whole point is to demonstrate to you what happens in an eviction trial when a landlord shows up unprepared. While trial in this case is being held via Zoom, you're probably finding that in your jurisdiction, more and more trials are being held in person. I am presently in Houston, and most of the cases that we see are in Harris County, and we're beginning to see many of the justice courts reverting back to in-person trials, and soon the county courts will also be back in person. But what's helpful about this video is that you're going to see how the court reacts to an unprepared landlord. To give you an idea of what I'm talking about, let's go to the tape.
4343 at the Parkway versus Kenneth Repsher. Probably I'll start with who you are and who you represent. Mr. Repsher, I know you're the defendant in the case.
Correct.
Okay. Ms. Dill, who do you represent?
I represent Mr. Repsher.
Okay.
So right from the start, we see the first of the plaintiff's errors, and that is that they showed up without counsel when the defendant clearly has counsel. You're going to see just how badly things go from this point.
And I don't know who's on the iPhone. You're muted.
Good morning, Your Honor.
Do you represent 4343 at the Parkway?
Correct.
And what is your name?
Elizabeth Ashley Clark.
Now, the judge asked her specifically, do you represent this party? I think that the court is convinced that this is counsel for the plaintiff. He used that term specifically, do you represent the plaintiff? And I think at this point, he's convinced that she is an attorney. We're going to see very quickly that she's not.
Okay. Are y'all expecting anybody else to join us?
No, Your Honor. I have a team member.
What was that?
I have a team member of mine as a witness. It did Miranda Carrion, who served the 3-day notice. She's across from me.
He's with you though. We don't need to bring him in on a separate Zoom. Is that right?
No, sir.
Okay.
No.
Are y'all ready to go?
Yes, sir.
Okay.
Yes.
The plaintiff may either make a opening statement or call your first witness.
Your Honor, I don't have a witness to call, and Miranda's here in presence if we need to on her relative to questioning with respect to the 30-day notice served at the time. I'd like to proceed with a rebuttal to the argument in the statement when the time's appropriate.
You represent the department, right?
43, if correct.
You're not going to offer any evidence?
I'm sorry?
You're not going to offer any evidence?
I think all of the evidence that we have has been sent to the JP court previously that should be in your documents, I presume.
I think this is where the judge begins to see that he misunderstands her role here, because very quickly she begins to say things that an attorney wouldn't say.
Well, this is a trial de novo.
Okay.
It starts over.
Okay.
Even though the judge says these things to her, I still don't think she gets what a trial de novo is. Essentially, the happenings in the justice court no longer matter. Whatever happened in the lower court is erased upon the perfection of the appeal. And because of that, you know, she could have had all sorts of really great evidence and really great testimony that was presented at the justice court, but none of that is relevant to the county court. By virtue of the appeal, the plaintiff is required to start everything from scratch. And while you get a lot of hand-holding in the justice court, you don't get the same in county court. And I think it is becoming clear to this plaintiff that she has to do things in a very, very different way, and she just doesn't know how. As always, landlords, we welcome you to follow us on Instagram, join our Facebook group, and if you enjoy the content that you're seeing, as always, give us a like. For those of you who haven't subscribed yet, please consider subscribing.
So perhaps I'm not clear on what documentation you do or do not have. If I need to submit copies of the 30-day notice, lease agreement, that sort of thing, I presume that those transferred.
Well, it's a new trial. I mean, you can offer whatever you wish to offer, but as of right now, I have no evidence of anything.
Okay, I can scan those over to Mindy.
Your Honor, I argue that the plaintiff is not ready to go for trial, and we were requested to submit all exhibits by noon yesterday. The defense is ready to go.
So counsel raises a really important point here. You're subject to the rules of the court. And if the court sent you a notice that says, you got to send a copy of the trial notice to the opposing side via certified mail, for example, you better do it, because then the court could sanction you in some way or continue the case or dismiss your case. Additionally, if the court requires that you submit all exhibits before trial begins, sometimes days before trial begins, and you haven't done it, the court could prevent you from submitting any evidence of your cause of action. And without evidence, you cannot win your case. Finally, if you're unfamiliar with the specific procedures, maybe you have to show up to a pre-trial hearing, or you have to exchange evidence with the opposing side, or you need to submit an exhibit list to the court before you show up to trial, your failure to do any one of these things could result in dismissal or delay. Make sure that before you attend your next eviction appeal that you've read everything that's required of you from the court. Remember, this is separate from what the law requires. The court could have its own individual rules that you have to follow in order to proceed.
If we ask for a continuance, we are prepared, but under the presumption that all prior documentation sent to JP court, and I was not familiar that we start over at the county court. My apologies for lack of understanding, but we're prepared to defend.
Anytime a case is appealed from a JP court to county court, it's a trial de novo, and so you're starting
okay.
over. You have to offer.
I was unfamiliar.
Yeah, you'd have to offer all the evidence that you intend to offer, and you have to offer in a way that's admissible under the rules of evidence.
Your Honor, since the plaintiff asked for a motion to continue this, I would request that you consider continuing this.
So ultimately, the court grants the continuance. Now, if you recall, the plaintiff requested that continuance, and the defendant has no problem with it. In fact, the defendant agrees that a continuance should be granted so that the parties could discuss the matter and see if there's some path to resolution.
Yeah, here's what happens.
It wasn't, though.
When a appeal from a JP court happens, there's basically there's no judgment anymore. That judgment is no longer final, and it shows up here just as it starts over. It's as if nothing has ever happened before. You have to prove up your entire case.
Another problem with an unprepared plaintiff is if you're unfamiliar with court procedure and you're unfamiliar with the process, you probably also don't know when to stop talking. So many landlords get themselves into trouble because they say things that are unnecessary, or they upset the court by just rambling on and on and on. You're not scoring any points by trying to convince the judge that you're right when it is clear that you don't know what you're doing.
What I am going to do, though, is grant a continuance. So give y'all, it'll probably be a couple weeks, though.
At this juncture, we're almost 6 months into no collection of rent, and so I will kind of counter. that we are ready to defend. My lack of understanding that we needed to start over with the county court, I very much was under the impression that the JP documents transferred. And so I don't, with your blessing, I don't need a couple of weeks, and I'd like an opportunity to defend that.
She doesn't understand that the court's done her a huge favor. In some cases, it would have been perfectly appropriate for the court to simply proceed with the trial as it was scheduled. The defense showed up. The defense is ready to present its case. The court is giving the plaintiff an opportunity to get its ducks in a row, and the plaintiff keeps talking as though there's some good that can come, as though she can convince the judge that she actually is prepared when it's very clear that she's not. The risk that she runs here is the court could say, sure, proceed. You have zero evidence. Are you done? Because the defendant is going to say, motion for ruling in favor of the defendant. The defendant is going to say, I don't need to prove anything. The burden is completely on the plaintiff. And because she is unfamiliar with procedure and because she doesn't know what she's doing, and I think that's very obvious to the judge, he is giving her a way out, but she presses and presses and presses. Fortunately for her in this case, the court disregards her continued claims that she's ready and simply resets the trial.
But I do know that when stuff shows up here, you're going to have witnesses to actually admit leases and those types of things.
Okay.
You have to follow the rules of evidence, in other words, once you get up here to proceed. So let's reset it for a couple of weeks.
Naturally, these are things that you can prepare for. If the court has sent you information about your case prior to your trial setting, make sure you've read all of it. And if you don't understand it and you don't understand normal court procedure on an appeal, seek out legal counsel. There's a phone number here that you can call at any time to book a consultation or ask a quick question. There's also my email address that you can use to reach out to us in the event that any of this is foggy or unclear for you. If you're in a Texas court, particularly with an eviction, and you have a question about what you can expect or what normally happens, ask before you show up. And if it turns out that this is simply a task that you're not willing or able to accomplish, give somebody a call. Find out whether or not you've got an attorney in your area, or give us a call and we can point you in a good direction if it's something that we can't otherwise step in to address. Whatever you do, landlords, don't be caught unprepared. If you want to know more about landlording, there's a video here that YouTube seems to think you'll like. Until next time, though, happy leasing.